Thank you, Tony, and welcome everyone to our webinar today, part of the U.S. and EU Cartel Investigation Series on search warrants and dawn raids. Please use the chat feature tool in WebEx to ask questions during the program. If due to time constraints we're not able to get through all the questions, please don't hesitate to contact one of us directly, and we're happy to follow up with you. As Tony said, if you need assistance, the lines are muted, but you can press star and then 0 on your phone, and he will assist you. The event is being recorded, and it may be posted on Arnold and Porter's website, where it'll be available to the public. Shortly after the program, we'll send a link with presentation materials to all the participants in today's program. To introduce our speakers today, I'm Will Mudge. I'm a partner here in the Washington, D.C. office of A&P. My practice covers a full range of antitrust matters, including mergers, counseling, civil litigation, and most relevant for today's purposes, criminal cartel investigations. My partner, Annette Shield, will be our other speaker today, and she's a partner in the Brussels office with over 20 years of antitrust experience. She also has a very broad portfolio of antitrust practice, including mergers, counseling, abuse of dominance cases, and cartel cases, including experience in a number of interesting dawn raid situations. So with that, again, welcome, and I will turn it over to Annette to give an intro and overview of the presentation.
Thank you very much, Will. And good afternoon, good evening to our audience, and welcome. You see the agenda on the WebEx. Basically, what we're going to do is to talk about the before, during, and after of a dawn raid. Only we're not going to do it in the order of before, during, and after. We'll start with the during and after, and then the conclusion of what the before needs to involve will be reasonably simple, we believe. So we'll give an overview of search warrants and dawn raids, do's and don'ts when the agents arrive, protecting the company's interests, what to do afterwards, and then again the planning ahead, namely the before. We'll look at the next slide. Both in the US and in the EU, the tool of dawn raids or search warrants is really quite common, although having chatted with my US colleagues, I understand that in the US it is much more rare that you immediately start with a search warrant, and that is much more likely that an investigation will start with a subpoena for documents. In the EU, you will very frequently have dawn raids at the beginning of an investigation. In the US, search warrants are also used in other criminal investigations. One commonality, again, is that both are executed without advance warning, and in fact, that is sort of the point. They are meant to be a surprise, and that's why plans and procedures must be in place before they are needed, because basically when you have agents standing at your doorstep, you don't have much time to think and plan how you want to proceed from now on. And here I hand over to Will again.
Thanks, Annette. So to begin, just to review some of the basics of a search warrant, this is an overview of the main elements of a federal search warrant under the Federal Rules of Criminal Procedure. State law requirements may differ. It's issued by a U.S. magistrate judge, typically. And it has to be based on probable cause to believe that a crime has been committed and that evidence of the crime will be found at the location that's being searched. It's supported by an affidavit, usually from the prosecutor, based on his or her personal knowledge, although often supported by hearsay, including from anonymous or confidential sources. And for that reason, it is the confidential sources. It is often filed under seal, and in fact, that's the practice. Either automatically by operation of rule or pursuant to a motion, it would be typically filed under seal. And it will describe the premises to be searched and the items to be seized, as we will see. So the next several slides in the presentation are just by way of example, so you can sort of see what the format looks like, although this is not an example from an antitrust case. This is the description of the premises to be searched. You can see that it's a fairly detailed description. And then the description of the items to be seized, which again should be fairly detailed. In an antitrust case, it should not just say, for example, any documents regarding violation of the Sherman Act. And we'll come back to the importance of the description of the premises to be searched and the items to be seized in a moment. But I will go ahead and turn it over to Annette regarding the equivalent issues in the EU regarding the authorization to inspect.
Yeah, obviously also in the EU, the inspectors will need some sort of authorization. On the slide, I'm listing two different types, one of which the undertakings may more or less ignore, and the other one of which they cannot ignore, where they are simply required to submit to the decision. Now, of course, I could tell you a lot about both of them, but frankly, most of the dawn raids are ordered by a binding decision by now. And if a company doesn't submit voluntarily, the EC may well end up using member state authorities, but also the police to get into the door. And so it's really not a great idea to resist. We also have an example on the next slide of what it looks like in the EC, just to show that we also know how to use the technology. But it's probably too small to read. So we'll tell you what's in it in the next slides. Now, next step, we have the agents at the entrance. The first people they meet tend to be either the security staff or the receptionists. And that's why it's very important that these people are prepared for this kind of event, because the group may be reasonably large. The group may be accompanied by police. They may have weapons, and they say, "I want to see everything immediately." So it is important that they don't react in too much shock, or a security guard just closes the door and say, "No, I won't let you in." In fact, they need to be cooperative, shouldn't ever be obstructive or hostile. They should know that they should provide an empty conference room with IT access, telephones, and so on, and tell the investigators that someone is coming to meet them, and then immediately contact this designated legal team and the IT managers. Now, the legal team, hopefully there is a lawyer on site, will request a copy of the ID of the inspector's team and their legal authorization documents, and then usually fax or send copies of the decision immediately to external lawyers who may hopefully have more experience with accompanying dawn raids than an in-house lawyer. The lawyers internally often ask the inspection team to wait for external counsel to arrive before commencing the raid. And indeed, sometimes the inspection team waits for a few minutes, but it's very important to know that they're not obliged to do so. And we have a case recently that, let's go for the next slide, that demonstrated that quite clearly, because there you were in a situation where, I think we are on the next slide. Okay, it's not coming. I don't know.
Having a brief technical difficulty with advancing the slide. I'll work on that.
Okay. Well, anyhow, the case concerned a situation where there was no in-house counsel on the site. There was basically no lawyer on the site. And so the people at reception, the security people, said, "Well, we need to have a lawyer present, and you can't come in, dear commission." That had the unfortunate effect that at some point the commission ordered the police to come, and they did enter, and then counted this as obstruction, which led to a 10% uplift in the fine. Now, it was a situation where I sort of feel for the Commission because they really were not let in, and during the time when they're not let in, the company could do all sorts of things internally to destroy documents or warn the competitors. But on the other hand, it's also important to note that the Commission couldn't got in for only 47 minutes, and that this led to an uplift in the fine of almost 3 million euros, which is quite significant. So it's important for, in that type of situation, to make sure that the inspectors can at least enter the premises, serve the inspection decision, and take all measures necessary to ensure that there's no destruction of evidence or communication with competitors. And the last thing, internally, you may want to warn the employees, tell them to remain calm, that there may be inspectors coming, and in particular that no documents should be concealed or destroyed. But that's something that you would need to agree with the inspectors. So now I'm turning over to Will again.
Yes, and I do apologize for the difficulty advancing the slides. I think we should proceed, and I will do that. And fortunately, the subjects I will cover next overlap quite a bit with what Annette has just been covering in terms of the preliminary response steps. They are in the U.S. quite similar to the situation in the EU, which is to say that the security and reception staff are the front line, the people that the agents will first encounter, and thank you. I guess we've moved on. We now have hopefully resolved our difficulty with the slides, so I'll move to the correct one, and there we are. So the security and reception staff are the front line, and their main jobs are to notify counsel immediately and to ask the agents to wait for counsel to arrive and not obstruct the search. As in Europe, the agents are not required to wait, and they probably won't wait for external counsel to arrive, although they probably will wait until internal counsel or some other person in authority arrives to escort them and to help make sure that the search is done in an organized way. Reception staff or security should also get the name and affiliation of the agents, and also the identity and affiliation of the prosecutor in charge. The prosecutor at whose behest the FBI agents are doing the search will not be present on site, but will be available by telephone. The reception staff should also inform the agents that he or she is not authorized to consent to a search, but that the company intends to cooperate. And this is an important distinction between cooperating and giving consent. So in this context, cooperating means you answer truthfully any questions the agents ask about where certain offices are, where documents might be, etc. But you do not give them consent to search a particular area, particularly if they ask you, may we search a certain area? Because that may indicate that they're not clear that they have authority under the warrant to extend the search into that area. And of course, always be polite and establish a rapport with the lead agent. That's particularly true of lead counsel, who will be heading up the response. And as in the EU, it's a good idea to give the lead agent in particular some workspace to use during the search. So the next major preliminary step is review the warrant for defects. The company is entitled to a copy of the warrant, and the agents will provide one. It doesn't hurt to also request the underlying affidavit on which the warrant is based, but since that's under seal, typically that request is usually going to be refused. Counsel should review the warrant for any kind of facial defects, such as the wrong address, failure to have it be signed by the judicial officer. By rule, the search is to be conducted within 14 days of issuance and generally between the hours of 6 a.m. and 10 p.m. That timing is usually not an issue in an antitrust case. If there is a defect in the warrant, counsel should point that out to the agent, the lead agent in charge, and object. And if the defect is serious, such as naming the wrong premises, the wrong address, then the counsel should ask the agent to halt the search. But if the agents refuse to do that, again, nobody should attempt to impede them or interfere with their continuing the search. Counsel can contact the prosecutor by phone if there's a problem with the warrant, but should do so only if the defect is serious. And nobody else other than lead counsel, preferably external counsel or experienced in-house counsel, should be contacting the prosecutor. And with that, I'll move on to Annette.
Well, obviously in the EU also the first thing is to read what they're allowed to do. And to some extent it's similar as in the US. The mandate will tell what they can do and what they can search. On the other hand, there's also already quite a bit in the applicable regulations. It may be somewhat less detailed than in the US from what I've seen. But you do want to know what products or services are covered. The Commission is clearly not allowed to go on a fishing expedition, so they shouldn't say all other products prepared that are made by the company or something similar. And you should also look whether there's anything that is unusual, such as a particular reference to homes of people, or basically premises that are not the natural ones to search of the company. On the slide you will find a reference to a recent court case that in Europe was, well, a lot of lawyers were quite interested in reading it because it was probably the first time a mandate was attacked successfully in front of the General Court. And the General Court basically found that there were no reasonable grounds for suspecting an infringement in at least some of the product markets that were listed on the mandate, and that led to the mandate being annulled, at least in part. Now, what that means for the decision, we will see, but it shows again it's important to be very careful and see what's covered. So here I think we're coming to the US again.
Okay, well, we will now move on to protecting the interests of the company during the search, and begin with the scope of search under the search warrant. As I mentioned earlier, the warrant itself describes where the agents can look and what they can copy or seize in the process of their search. And lead counsel should attempt to keep the search within the boundaries described in the warrant, including not only the areas that are actually described, but areas that are likely to contain the materials that are described in the warrant as to be seized. If the agents get outside these boundaries, the counsel should object and make a record of those objections. But if those objections don't produce any results, again, the watchword is don't actually attempt to interfere or prevent the agents from searching where they intend to search. And it's usually advisable to strike a balance between objecting when necessary and avoiding unnecessarily antagonizing or being confrontational with the agents over minor discrepancies. So, object politely, make a record. If there's a serious issue that's, a major departure from the scope of the warrant, something that's particularly burdensome or is going to result in a lot of additional materials being seized, counsel can consider escalating, giving a call to the prosecutor, or even raising the matter with the court. But again, that's something that should best be done only by experienced counsel, whether outside counsel or inside counsel, and should not. It's not a step, particularly taking something to the judge if you can't get the prosecutor's agreement is not a step that should be taken lightly. With respect specifically to privileged documents, The attorney-client work product privileges do apply, and agents are not attempting to seize or not entitled to seize and review privileged documents. But the fact is, it does happen because these documents are often commingled with other materials, and the seizure is happening quickly and in usually not a very precise way. So lead counsel should do his or her best to identify likely privileged documents, particularly in places where a large number of those might be found, like the files of an attorney, and object to having these searched until a procedure can be worked out with the prosecutor for protecting the privilege. That can include sealing the documents until company counsel can review them. You may be able to get the prosecutor to agree to receive those documents by subpoena. A common procedure is for the government to use a privilege team, sometimes called a taint team, where they have a team of agents and lawyers that are not involved in the investigation previously and won't be going forward, to be tasked with just identifying which documents are privileged and which are not, and then they would only share the non-privileged material with the prosecutors who are actually handling the substance of the case. That's less desirable, obviously, than arranging a situation where company counsel can review the documents, because that government team, is just not going to have they won't have the same perspective on privilege, obviously, but they also won't have all the underlying information that they may need to make accurate judgment calls there. In any event, these are steps that the agents may not agree to, particularly if you're asking them to defer collection of certain documents. And of course, do not attempt to prevent them from seizing the documents if they are insistent on it, but do make a record of your objections. And these privilege issues are a good topic to raise with the prosecutor, because you're likely to get farther with him or her than with the agents, and it's something where you may be able to work out a solution. So now I will turn it over to Annette again to discuss the scope of the search in the Dawn raid context.
Mm-hmm. Thank you, Will. Where can the EU search? Company, premises, land, and means of transport, so also cars that may be outside and where people have their files. Usually you don't have to worry too much about it, because if there is a court order necessary, then the EC usually comes with it. And otherwise, the National Competition Authority would seal the premises until whatever is needed is obtained. Private homes is a bit more complicated in most of the member states, and it's also much more rare. On the other hand, one thing that's very important to bear in mind, and that shows again how important it is for people to be prepared and counsel to be present, is that I've been in several situations where all of a sudden the employees volunteered and said, "Oh, no problem, let's go to my home. Yes, it's true, I have my computer there and I have a few files because I wanted to work on them. Absolutely no problem." Now that it's very difficult to get away from that again once the person who has the right to object has volunteered. And so it is important to stop them, because it can be terrifying for the people who are at the home, and also it is not necessary. What can they search for? Documents in any shape or form or format, that is to say on paper or electronic means. Could be records, diaries, could be train tickets, expense reports, but it could also be the list of who you called on your cell phone. So it's a really very wide definition of what constitutes a document that can be searched. And if the Commission knows that certain documents must exist at the company but can't find them immediately, the company is actually obliged to produce these documents because there's an active duty to cooperate. And if you do the opposite and try to hide things or avoid handing them over, that may be construed as a failure to cooperate. So in practice, very little is safe. They can also look at smartphones used for work purposes, private email accounts, if they're used from the office, very often are particularly suspicious. And again, when I was younger, I was in the very unfortunate situation that the employee was telling me, you have to explain to the commission that I use this to communicate with my girlfriend. You can definitely not look at this. Now, this was the private Hotmail account that was used to coordinate the cartel. And the commission knew that, and we sailed by an obstruction charge at that point. Are there any limits at all? Well, they're the same ones as in the US, namely the document needs to be relevant to the subject matter of the investigation. And if it isn't, then you should sort of show enough to the inspectors to make sure they understand, and if not, you should seal them. Or, of course, also, if the document is privileged, they're not allowed to take it. Again, the question is, if there is any debate about it, the documents should be sealed. Let's do quickly something on privilege on the next slide, because I think there are some differences between the EC and the US. Because in the EC, privilege is really only accorded to outside counsel that is qualified in the EU. So internal lawyers do not have any privilege, as all the Europeans on the line know and have been fighting against for many years. But it may be less known to our US colleagues. And then, of course, also somebody who's not admitted in outside counsel, who's not admitted in the EU, can do whatever they want, but the communications with them will not be privileged. And of course, there's also a limit. Not everything that is written by an outside counsel it will be privileged. It needs to be linked to the subject matter of the proceedings. Whenever a privileged document is reviewed, best is probably to disclose, again, whatever is necessary to show it's privileged. And if there is a disagreement, as mentioned, should be sealed. And then there should be an appeal to the hearing officer. Much better than fighting on the day with the agents. They usually don't have time for that. It just leads to aggravation. Just put it in an envelope, seal it, and deal with it later. And we're back to the US.
Okay, thanks, Annette. So moving on to observing the search, making a record of what is seized and where the agents have searched is a key goal for a couple of reasons, both to just let you know what they may be investigating based on what they've actually seized and what evidence they will have in their possession as you move forward with the internal investigation, and also to identify anything that may be missing that the company is going to need to carry on its business going forward. So lead counsel should assemble a team. It will usually need to be a team because these document-intense search warrants in the antitrust context would typically involve a number of agents searching. So you need to assemble a team of employees, ideally folks like inside counsel or security staff, to shadow the agents, to follow them as they search and take detailed notes of where they look and how long they look and what they seize and what they say or ask during their search. Counsel should consider asking to videotape the search. That's an efficient way of recording what the agents are doing. But the agents may not permit this. In fact, they may object to being shadowed at all. They may assert that this interferes with their search, that they need to protect agent safety, so they shouldn't have someone standing over them, that it interferes with an orderly search. So this is a point where even though the company really should be able to follow and document the search, you may meet resistance from the agents. They also tend to secure employees outside the search area and move them outside the search area except as necessary for the employees to guide the search. So again, these are kind of best practices and what you should attempt to do, although wouldn't be terribly surprising if that's not entirely successful. And in any event, being polite and staying out of the agent's way is important to maximize the chances that you'll actually be able to follow the agents and take good notes of what they're doing. And to cover the same topic in Europe, I'll turn it back to Annette.
Yeah, I don't have an awful lot to add because I think the role of people shadowing is very similar. Check whether nothing is done that is completely out of line. That, again, documents are collected that are privileged, and also take notes of any questions asked or anything handed over. But in practice, I have found that the most useful things shadowers do is really to facilitate that things run smoothly. That doesn't mean that they point out, oh, you should be looking in that cupboard. No, certainly not, if the commission doesn't want to look there. But it does mean making sure that the employees who may be frightened, who have no idea what's going on, don't just close the door or say, no, I will not give you my password for the computer. Explain to them what they're obliged to do and facilitate within the framework of what you have to do the work of the commission. That is extremely important and really helps in the end. And otherwise, I think there isn't that much difference. So that's why I'll hand up to Will right away.
So to pick up on something Annette was just saying regarding facilitating the search, the company is certainly under no obligation to volunteer information to the agents, but it will often be the case that providing some assistance, more or less in the nature of logistical assistance to the agents, while being careful to make clear that you're not actually consenting to the search, either generally or to search of any particular area, may minimize disruption to the business and prevent the agents from collecting too much that they really don't need to collect, shortening the search because it's obviously very disruptive for them to be on the premises. So you want to get them out of there, to be candid, as quickly as you feasibly can, and to avoid them entering areas where they really don't need to go to get what the warrant describes they're supposed to be looking for. Similarly, you're going to want to try, the lead counsel are going to want to try to get copies of anything that is seized. This can be a daunting task, but ideally you would want to have employees make copies of anything that is seized and obtain some help from your IT department to provide technical assistance with copying or imaging any electronic information that the agents may be seizing, because it will minimize the risk that they will just end up seizing computers, servers, drives, durable media, and taking it all off-site. So these goals are a little bit aspirational in the sense that, as I said earlier, you may not have 100% success, but those are definitely what you should be trying to accomplish as lead counsel in a search situation. And again, the agents may not agree to cooperate with you on some of these points. And if so, you can try to obtain copies of any documents that you don't get copies of at the time of seizure. You can try to obtain them subsequently, negotiating with the prosecutor. And for the same topic in the EU, I'll turn it back over to Annette.
Yeah, I mean, it sounds like our life in the EU is at least a little bit easier than in the US, because the inspectors will only take copies of things, in particular paper, unless there is a hard disk that they don't get through and there's no other way. But if they take copies, that means you also get a copy of whatever they take a copy of. And that applies both to paper documents and electronic documents, which indeed does make it very important that all the facilities are available that they need. So they should have lots of copiers, and then the easiest is usually to have somebody then copy what they've copied, so you have a version for the company also. When it comes to accessing IT, the Commission will usually come with some IT specialists who have their own dedicated software to copy, search, and recover data. And they can use the company software, but they can also use their own. We've just had a question that I think would make sense to answer in this context. When they're searching on electronic means, the EU takes the position that they are allowed to access anything that can be accessed from the EU. That is to say, if the server is located outside the EU and the document is on the server, but you can access the document from wherever the Commission is searching, they consider that they are allowed to download that if they think it's relevant to the investigation. I think it's slightly different from the Department of Justice, but I won't opine on it too much. Other things are similar. Of course, you're not too keen on having anybody mirror the entire content of a PC if that's not necessary. On the other hand, you should help with things like encryption and password-protected documents. And you have an interest in doing it all swiftly, because otherwise either they take away the hard disk and you look at it together at the Commission premises at some other time, or they seal the premises where documents are located. And we actually have a seal on the next slide, just so you see what it looks like. Those things have been talked about a lot in the EU since the EU started fining companies for breaking of seal. And you can see in the middle one what it looks like if the seal is broken. You have this void. The cases are mentioned on the next slide in case you're interested. Just for the people outside the EU who may not know, I think the highest fine ever imposed for breaking of a seal was 38 million. That was on E.ON. It was the courts who all confirmed that this was lawful, basically emphasized that was much less than the Commission could have fined. Namely, they could have fined 1% of worldwide turnover, and it was indeed much less than that. But it's still a significant amount of money for a seal being broken, and even if nobody went in and destroyed anything. So it's very important for companies to make sure to protect seals once they're there. Inform the cleaners who may come by with a vacuum cleaner, but also more importantly, just put cameras, or in the best case, use security guards. That's going to cost significantly less around the clock than a few million fine. So I think we're back to the US.
Okay, thank you. So we've now come to the phase of the search at the end of the day. In the U.S., pursuant to federal rule, that the agents must prepare an inventory and a receipt for property seized, and they must prepare it in the presence of the person whose materials are being seized, if that person is available. And they have to do it before they actually leave the premises. They can they would leave it behind if the owner of the premises is not available, but in this case they'll give it to you, give it to counsel. It should be accurate, and you should review it for accuracy, but it's often not very detailed, which is why counsel will want to supplement the inventory with the notes that counsel or other observers who were shadowing the agents will have taken, and notes from any interviews of employees who may have been interviewed by the agents, as we'll talk about in a minute, or who may have observed the search either because they were signed to do so, or because they just happened to be in the area, or their office was searched, etc. They have some idea of where the agents looked and what they took. And Annette can address the EU situation, which is pretty similar.
we are, I think we are in a quite fortunate position because not only do we get an exact copy of what, or sometimes even two for the outside lawyers and the company of what the commission is taking, but we also have inventories that are extremely detailed. And at the end of the day, it may take quite a while to check between the commission and the lawyers whether the inventory is accurate, because you go together, you look at all the documents, you go through, is the inventory complete? And usually it's very easy to agree if something is wrong, because everybody has an interest in having an accurate inventory in the end. So we have an easy life. How about the U.S. again?
So I mentioned we would talk about employees and interviews, and we'll move on to that now. Lead counsel should gather the employees together, those who are affected by the search, whose work area is being searched, inform them about what's going on while the search is happening. And generally speaking, the agents, as I mentioned, will have cleared folks out of the search area, and they may be gathered in the cafeteria or the break room, a similar situation. The counsel should remind the employees not to destroy or conceal evidence, delete anything, alter anything. That would be obstruction of justice, or could certainly be treated as obstruction of justice, and that's a felony in the United States. It is punishable by imprisonment, and DOJ takes obstruction extremely seriously. They have a policy, the Antitrust Division, I know, has a policy that and it may be DOJ-wide, that if there's obstruction, they will not recommend a no-jail sentence, no matter how cooperative the defendant has been. So you need to inform the employees that they can decline to be interviewed. It's important, right? So they can agree to an interview, but it's entirely at the employee's discretion. But counsel will want to be very careful here, because you must take care not to suggest that the employees should refuse to speak with the agent, because that too could be treated as obstruction. So employees need to be made aware that they can agree to an interview, but it's entirely at their discretion, and they don't need to do that. You should advise employees not to discuss the search with anyone else other than company counsel or the agents if they agree to speak with an agent, and especially not with the media. We'll get to that again in a little while. The senior managers of the business present, in consultation with counsel, should consider closing the affected areas of the business that are being searched, and to send any non-essential personnel home for the day. So obviously anyone who's helping with monitoring the search, facilitating the search should remain, and anyone else who's essential, but everyone else could go home. Employees should be reminded, though, also not to consent to the search in any area. And generally, employees should be saying that they don't have authority to consent to search on behalf of the company, which is usually correct. We have a little more on employee interviews specifically. Not only can an employee decline to be interviewed, he or she can set limits on what they're willing to talk about, the subject matter or the time. They can refuse to answer particular questions, and they can end the interview at any time, as long as they do it politely. And that's the case unless the agent informs them otherwise, and that would only be in the event they're being taken into custody, which is quite rare in an antitrust context. It might occur in the case of if the agents believe there were obstruction, but probably not otherwise. Employees have a right to have legal counsel present if they do agree to any interview, and that can be company counsel or if they had personal counsel. You should tell the employees that the company requests that they notify the company before participating in an interview, so the company counsel can join in. Note that, though, this is important as well, that if the employee does agree to be interviewed, he or she has to tell the truth. Otherwise, they could be prosecuted for making false statements. So the interview is optional, but telling the truth is not if you're going to talk. And just note that agents will often conduct interviews or execute warrants at employees' homes, and the same rules are applicable in that context as would apply in the workplace. And for more on employee interviews, I'll let Annette address Europe.
In Europe, we have two different types of situations that are treated quite differently. First of all, if an inspector is in an office and the employee is there and the inspector needs help understanding certain facts, they look at some document and simply don't understand it, then the employee has to respond. The investigators should not ask questions that would lead to a self-incriminating response, but purely factual things and explanatory things employees will need to respond to on the spot. Of course, if the question is too complicated, they should say that, and they should not ever volunteer anything or go beyond the question or the answer to the question. But at least there you have one type of situation where people need to respond in order to not to be seen to obstruct the investigation. An entirely different type of situation is that the Commission also can ask for statements from company representatives and employees. Those it could interview people at its own premises, but it sometimes also asks to do that during a dawn raid, and that is something where employees can object, and usually, given how stressful the entire situation is, and that it's almost impossible to tell them about their rights at that moment, and they actually retaining their rights, usually they should object to that also. Now, if they consent, then the inspectors can ask pretty much any questions. Counsel should be present. Somebody will take notes, and the usual rules apply. Obviously, nobody should, none of the people interviewed should guess or offer views or opinions. Very often they should just respond, I don't know, or they should say, well, if something's too complicated, then I will respond in writing at a later date. Fortunately, at the end of the interview, the inspectors will give the person who's been interviewed the possibility to look at what they've noted, and they need to approve it. And the company will get a copy of that statement. And even better, usually you will get a few days to correct statements, which quite often may be necessary because the first time somebody is confronted with an accusation, they may say all sorts of things, and having thought about it with the help of a lawyer afterwards, they may change their views. And as long as you correct the statement in the time period that is given to you, at least that will not have any negative consequence. Afterwards, yes, we are in the same situation as the US, but at least you have a little bit of time to correct. Now we come to obstruction. Just throughout the webinar, I've mentioned several times that you should not obstruct the investigation, and so now I just want to give you the reasons for it. Namely, fines up to 1% of worldwide turnover in the preceding year. We've mentioned that already with the breaking of the seal, but I think it is worth mentioning again. And in particular, since the Commission seems to get a little bit more aggressive on actually sanctioning people. We have a sanction for failure to block an email account. It was actually pretty egregious because they diverted all the incoming emails. Nevertheless, it did lead to a high fine. Destruction of documents, obviously, we've mentioned that already, can get to quite a significant uplift in the fine. Or the refusal to provide oral explanations, or again, destruction. There you actually had an increase of 30% in the basic amount of the fine imposed, which is getting to be quite significant. So I think that's all I want to say about obstruction at this point. And so we get back to US.
Okay, thank you. And so now we come to The search is over, and now what do we do? And I think you'll find as we go through that the steps for the U.S. and the EU are quite similar. So to begin, lead counsel should collect observers' notes and interview employees who saw the search take place or were interviewed by the agents. And this should happen as promptly as possible for a number of obvious reasons, but also including that you will want to capture any information that's not written down while memories are fresh. And as mentioned, you'll want to use this information to supplement the inventory that the agents provided of the materials that they seized. And so obviously the information you want to get at here is, where the search was conducted, how long the agents spent, what they took. And all of this information, in addition to supplementing the inventory of what was taken, should be figured into a file memo that will be broader than just what was seized, but basically documenting all of the important details of the search, including all the information you captured about about who the agents were and their affiliations and contacts, and basically anything else about the search that counsel has learned through the course of the day. Another immediate step to take is to contact the public relations staff or media relations team. The fact of a search such as this, a search warrant execution or a dawn raid, may become public, and it may become public pretty quickly. And so the company's media relations people need to be prepared for that, and it's counsel's role to make sure that they are. Typically, in the immediate term, particularly when the search is actually being conducted, no comment is appropriate and popular response. Thereafter, it's common to confirm that the search took place and that the company is cooperating with the authorities. It's more rare to go beyond that, and in any event, the company shouldn't say anything without consulting counsel first. In terms of other next steps, obviously the search warrant is a wake-up call that the government has enough evidence to believe that crime has taken place, and that your company's got evidence that at the location of that crime. So you'll want to put in a document hold for any documents relating to the subject matter of that investigation, to the extent you can determine what the subject matter is. And you'll want to consult experienced counsel about putting that in place, and you want to do it right away. And relatedly, this should be the start of the company's internal investigation of the facts underlying the search and how it is that the government came to believe that there was a crime here. This is particularly important given the importance of amnesty and cooperation credit and the role of being first or early to engage with the government on those. And also, to the extent materials were seized that the company was not able to retain a copy of, particularly things that are especially important to the operation of the business, you'll want to initiate discussions with the prosecutor about getting copies of that stuff back. And very similar in the EU. I'll let Annette address that, though.
Yeah, indeed, things are very similar. Very often the fact that the dawn raid is taking place is leaked by someone, so it's extremely important that your media is prepared to say something. Either say no comment or confirm that there was a raid, because it's known anyhow, and that the company is cooperating with the commission. That's the usual response. Also, like in the US, it is really important to try and figure out what's happened. What documents have been seized, but also simply get the story from the employees who are the most likely to know about it, simply because the reduction in the fine that you can get if you add significant value, even after a dawn raid has taken place, is still extremely significant. So you really have an interest in figuring out whether you can still contribute something, maybe some documents that the Commission did not find. Then we've already talked about correcting statements, following up with the inspection team if certain files are going to be reviewed off premise, or following up with the hearing officer in case there's some documents that you consider as privileged and that the Commission did not agree on. I think that was the EU. And now we finally come to the beginning with Will at the very end.
Okay. So we've come to the planning ahead, as Annette said, which, having been through all of the during and after, you will understand why these steps make sense. A key aspect is to make sure that the company has identified who inside and outside counsel will be the points of contact when the agents show up to search. Preferably folks who can arrive on the site quickly, and obviously, ideally, particularly with respect to the outside counsel, folks who have experience in handling these kinds of search situations. And that information, the identity of who inside the company as counsel and business leaders, and also who the outside counsel are, that information should be readily available to the security staff, to the receptionist, those on the front line who will greet the agents, so they can spring into action, so to speak, when the agents arrive. We referred a few times to lead counsel throughout the presentation. The company should figure out who they want to have as the lead counsel. Could be, in some situations, not an attorney but a compliance professional, particularly if an attorney is not available, but someone preferably at each facility to lead the company's response and take all the steps that we referred to earlier. And it's important to have someone at each facility if possible, because, as we mentioned, neither the EU authorities nor U.S. agents are likely to wait very long before commencing their search. So you need to have someone right nearby. The company should also identify fallback options, individuals who would lead the response if the initial leader or outside counsel who would be first in line isn't available that day because maybe they're traveling or ill. So have, and probably more than one person on the depth chart, so to speak, for each of those roles. And finally, certainly last but not least, you need to conduct a thorough training for all the key employees who will have to execute these steps in response to a search warrant or a dawn raid. We mentioned a lot security and receptionists, also senior managers, business leaders who are at each facility, and the IT staff who may have to assist, and records managers at each facility who, for obvious reasons, will be part of the response. So,
and maybe there's one.
Yeah, I was just going to say, if you had anything to add, Annette.
Well, just for the very last one, I often hear that companies are saving on things and that it's difficult to get the money for the training. At least for those in Europe, I'd be very happy to send you that court decision, that court judgment, where basically the lack of training of the security staff led to a fine of 3 million. And I think that should help. So I'd be very happy to do that.
Okay. Well, and with that, we've reached the end of the presentation, except for questions. We are just right about at the end of the hour that we had scheduled, but perhaps we can take a couple of additional questions. I see one question we had is that we've shared a lot of information regarding employees' rights and do's and don'ts for employees, and that this seems like a lot of information for employees to keep straight. How does one ensure that employees will know and remember all of that information? And I think the answer to it is really twofold. As we were just mentioning, training is key. There is some fairly complex information that at least certain employees have to have absorbed, and and training in advance will be an important part of that. I can think of in the U.S., for example, the difference between consent and cooperation is somewhat nuanced. So training, and obviously there are a lot of materials available out there for training on this point, and we certainly are happy to assist with providing that kind of training for employees as well, or to work with Inside Counsel to develop that. The other piece I was going to mention is assembling together the employees while the search is taking place. Again, whoever's going to brief those employees in that circumstance needs to know what to brief them on, and that too is a function of planning ahead, training the individuals so that they know what to say and what information to share when the time comes. So that was my answer to that question. Annette, did you have anything to add on that?
Well, actually, I think I would say pretty much the same. And so I was going to jump to another question that we received that specifically addressed the EU. And that was whether basically what we're saying is applicable to all dawn raids. And I'm extremely grateful for that question. I mean, first of all, I could not speak about every dawn raid that happens in any other area than antitrust, but in antitrust, there are, of course, also dawn raids by national competition authorities, and they have their own rules. Much of what we say does apply to those also, but some of it doesn't, because in some member states we have criminal liability, and the investigating authority has much more rights, many more rights, and so you actually need to be trained in that too if you happen to live in the UK or Ireland, for example. There's also a few other countries, but they don't tend to apply their laws all that much. So this is really a very rough outline that is not going to be enough for every training. I don't know, Will, did you have another question? Or maybe we're too late at this point and we should answer in writing.
Well, we did start a bit late, and we've gone over our allotted time by just a bit. So maybe it would be best. I think we do have a couple more questions, or a few more. So maybe the best thing would be for us to follow up offline, which we're very happy to do with on any of these further questions.
And we thank all of those who are still online very much for listening.
Absolutely, thank you very much. It's been a pleasure, and obviously we're happy to discuss further one-on-one any of these issues. Dominance cases and cartel cases, including experience in a number of interesting dawn raid situations. So with that, again, welcome, and I will turn it over to Annette to give an intro and overview of the presentation.
Thank you very much, Will. And good afternoon, good evening to our audience, and welcome. You see the agenda on the WebEx. Basically, what we're going to do is to talk about the before, during, and after of a dawn raid. Only we're not going to do it in the order of before, during, and after. We'll start with the during and after, and then the conclusion of what the before needs to involve will be reasonably simple, we believe. So we'll give an overview of search warrants and dawn raids, do's and don'ts, when the agents arrive, protecting the company's interests, what to do afterwards, and then again the planning ahead, namely the before. We'll look at the next slide. Both in the US and in the EU, the tool of dawn raids or search warrants is really quite common, although having chatted with my US colleagues, I understand that in the US it is much more rare that you immediately start with a search warrant, and that is much more likely that
hearsay, including from anonymous or confidential sources. And for that reason, it is the confidential sources. It is often filed under seal, and in fact, that's the practice. Either automatically by operation of rule or pursuant to a motion, it would be typically filed under seal. And it will describe the premises to be searched and the items to be seized, as we will see. So the next several slides in the presentation are just by way of example, so you can sort of see what the format looks like, although this is not an example from an antitrust case. This is the description of the premises to be searched. you can see that it's a fairly detailed description. And then the description of the items to be seized, which again should be fairly detailed. In an antitrust case, it should not just say, for example, any documents regarding violation of the Sherman Act. And we'll come back to the importance of the description of the premises to be searched and the items to be seized in a moment. But I will go ahead and turn it over to Annette regarding the equivalent issues in the EU regarding the authorization to inspect.
Yeah, obviously also in the EU, the inspectors will need some sort of authorization. On the slide, I'm listing two different types, one of which the undertakings may more or less ignore, and the other one of which they cannot ignore, where they are simply required to submit to the decision. Now, of course, I could tell you a lot about both of them, but frankly, most of the dawn raids are ordered by a binding decision by now. And if a company doesn't submit voluntarily, the EC may well end up using member state authorities, but also the police to get into the door. And so it's really not a great idea to resist. We also have an example on the next slide of what it looks like in the EC, just to show that we also know how to use the technology. But it's probably too small to read. So we'll tell you what's in it in the next. Now, next step, we have the agents at the entrance. The first people they meet tend to be either the security staff or the receptionists, and that's why it's very important that these people are prepared for this kind of event, because the group may be reasonably large. The group may be accompanied by police. They may have weapons, and they say, "I want to see everything immediately." So it is important that an investigation will start with a subpoena for documents. In the EU, you will very frequently have dawn raids at the beginning of an investigation. In the US, search warrants are also used in other criminal investigations. One commonality, again, is that both are executed without advance warning, and in fact, that is sort of the point. They are meant to be a surprise, and that's why plans and procedures must be in place before they are needed, because basically when you have agents standing at your doorstep, you don't have much time to think and plan how you want to proceed from now on. And here I hand over to Will again.
Thanks, Annette. So to begin, just to review some of the basics of a search warrant, this is an overview of the main elements of a federal search warrant under the Federal Rules of Criminal Procedure. State law requirements may differ. It's issued by a U.S. magistrate judge, typically, and it has to be based on probable cause to believe that a crime has been committed and that evidence of the crime will be found at the location that's being searched. It's supported by an affidavit, usually from the prosecutor, based on his or her personal knowledge, although often supported by. Thank you, Tony, and welcome everyone to our webinar today, part of the U.S. and EU Cartel Investigation Series on search warrants and dawn raids. Please use the chat feature tool in WebEx to ask questions during the program. If due to time constraints we're not able to get through all the questions, please don't hesitate to contact one of us directly, and we're happy to follow up with you. As Tony said, if you need assistance, the lines are muted, but you can press star and then 0 on your phone, and he will assist you. The event is being recorded, and it may be posted on Arnold and Porter's website, where it'll be available to the public. Shortly after the program, we'll send a link with presentation materials to all the participants in today's program. To introduce our speakers today, I'm Will Mudge. I'm a partner here in the Washington, D.C. office of A&P. My practice covers a full range of antitrust matters, including mergers, counseling, civil litigation, and most relevant for today's purposes, criminal cartel investigations. My partner, Annette Shield, will be our other speaker today, and she's a partner in the Brussels office with over 20 years of antitrust experience. She also has a very broad portfolio of antitrust practice, including mergers, counseling, abuse of